Hi, everyone. Judge Andrew Napolitano here for Judging Freedom. Today is Thursday, April 20th, 2023. It's a little past 4:30 in the afternoon here on the East Coast of the United States. Here are your hot topics, and some of these are hot, and one of them just happened a couple of minutes ago involving Alec Baldwin. But before we get to Mr. Baldwin and his legal issues in New Mexico, you will recall our conversation earlier in the week in which I said the Supreme Court needed to rule on abortion by 11:59 in the evening on Wednesday. Well, here it is Thursday afternoon, and the court hasn't ruled yet. When you're the Supreme Court, you get to change the rules, move the goalposts, so to speak, for yourself. So the Supreme Court, probably because it hasn't come to a consensus on what to do yet, has given itself until Friday evening, that's tomorrow, Friday evening at 11:59 to rule. Just background. In 2020, the Food and Drug Administration approved a drug known as an abortifacient. This allows the mom to self-abort by taking the drug. Periodically, since 2020, it modified the rules governing the drug. First, it said you can only get the drug from a doctor. Then it said you can only get the drug from a doctor after an examination. Then it said you don't need the doctor. Then it said you can get the drug by mail. Each time it addressed this drug, it made it more readily available based upon its perception of public pressure and the wishes of the pro-abortion folks in the public arena. When this was challenged before a federal district court trial judge in Texas, and at the same time before another trial judge in the state of Washington, they ruled the opposite. The judge in the state of Washington said there's nothing wrong with the way the FDA made its findings, and there's nothing wrong with these subsequent changes. The judge in Texas, however, said the FDA never had the authority to rule in favor of the abortifacient in the first place, and so its initial ruling, as well as all these subsequent changes, is invalid. So what do you do if you're confronted with a red light and a green light at the same time? Interesting question. As a matter of law, the red trumps the green. Therefore, even though one federal judge said it's okay because another federal judge expressly enjoined the Food and Drug Administration from making the drug available, the manufacturer of the drug lacked a license to manufacture it and sell it. So anybody who had the drug can use it, but anybody who wanted to buy it, unless it was in storage in a facility at the drugstore or the pharmacy, wouldn't be able to get it from the manufacturer. That decision was appealed to the appeals court in New Orleans, which is where the appeals court for federal district court judges in Texas is headquartered. And that appeals court said, we're going to partially uphold this and partially change it. We're going to let women use the drug, but they can't get it by mail, and they can only get it from their doctors. Then the DOJ appealed that to the Supreme Court. Then Justice Samuel Alito said, I'm putting everything on hold. We're back to where we were before this Texas trial judge ruled. The manufacturers of the drug have the license. The FDA validation of the drug is lawful until the Supreme Court can rule, and he gave the Supreme Court until Wednesday night. Late Wednesday came, Justice Alito issued another order extending the time for the Supreme Court, himself and his 8 colleagues, until Friday evening at 11:59. So we can expect a ruling in the next 30 hours. This is not a final ruling on whether this drug will be available. This is just an emergency ruling on whether this trial judge in Texas did the right thing by enjoining everybody in the country from getting newly manufactured versions of the drug. Obviously, if you already have it, you can take it. I can't tell you which way I think the Supreme Court is going to go. This is not a ruling on the lawfulness of abortion. Abortion isn't even a federal issue. If I were free to do so, I would rule that the FDA has no business authorizing the drug. it's up to the states to decide what to do on abortion. That's not me. That's the Supreme Court last June in the Dobbs opinion, interestingly, also written by Justice Alito. So I don't know which way the court is going to go. I think it would be embarrassing if they gave themselves another extension. So expect some ruling, not on the merits, but on whether or not the trial judge in Texas, whether or not his ruling can stand during the pendency of the litigation in which the FDA's decision-making is challenged at a trial. And we should probably hear that by the end of the day tomorrow, or if you're watching this tomorrow, by the end of the day Friday. While that is going on, the House Judiciary Committee subpoenaed a guy named Mark Pomerantz to testify before it. You probably never heard of Mr. Pomerantz. I had never heard of him until a couple of weeks ago. Mr. Pomerantz is a former federal prosecutor in New York City who had been hired by Cy Vance, then the district attorney in New York City, to spearhead a case against Donald Trump for various alleged crimes that Mr. Trump is alleged to have committed before he was president of the United States. Pomerantz and his team compiled an enormous case against Trump, alleging a variety of crimes: racketeering, tax fraud, wire fraud, mail fraud, insurance fraud. Presented all of that to Alvin Bragg when he became the DA, who said, "I'm not going there." Then Mr. Bragg changed his mind. Then Mr. Bragg sought an indictment on the basis of Trump using personal funds, using corporate funds to pay a personal debt or a campaign debt, either way, avoiding paying state and federal taxes on those funds. And that's essentially what he was indicted for earlier this month. Why do they want to subpoena Mark Pomerantz? Well, when Alvin Bragg decided not to prosecute Donald Trump, Pomerantz resigned from the DA's office and wrote a book about it. And the book is highly critical of Alvin Bragg. So the Republicans on the House Judiciary Committee want to know, what is your criticism of Alvin Bragg? Is there a wrong going on here? The DA filed an application before a federal judge to quash, as in squash, the subpoena to Mark Pomerantz. And a federal district court judge late yesterday said, no, there's nothing wrong with the subpoena. Congress can interrogate anybody about anything it wants. The DA appealed that to the United States Court of Appeals for the Second Circuit, which said, hold on, no subpoena, no testimony until we can look at all of this. So the House Judiciary Committee's victory was short-lived. It doesn't necessarily mean that the three-judge panel, which stayed the effect of the trial judge's decision, is going to rule the same way after they look at all the documents in the case. It just means that they didn't want to rule under the gun, because Mark Pomerantz's testimony was scheduled for today. So first thing this morning, that Circuit Court of Appeals panel of three judges said, put everything on hold so we can look at the documents and we'll decide if this trial judge made a mistake. So for now, no subpoena, no testimony, no deposition of Mark Pomerantz. You'll hear this name a lot more, either because they won't let him testify and you'll hear the Republicans howl over this, or they will let him testify and you'll hear the Republicans gloat over what he tells them in a deposition. While this is going on, an IRS agent has become a whistleblower and complains that the investigation of Hunter Biden and alleged income tax evasion is giving him special treatment. Now, Hunter Biden is under investigation for a number of crimes, but the most serious one is income tax evasion. And the authority doing the investigating is the United States Attorney for the District of Delaware. That's the chief federal prosecutor for the state of Delaware. As all of you know, there are chief federal prosecutors all over the place. Depending upon the size of the state, some have more than one. New York has 4. New Jersey has 1. Delaware has 1. Pennsylvania has 3. So it just depends upon the geography and the population of the state. This particular federal prosecutor in Delaware was appointed by Donald Trump, not by Joe Biden. Joe Biden, to his credit, knowing this investigation was ongoing over his son, did not ask the Trump-appointed U.S. attorney to resign and appoint a replacement, as Joe Biden did to many other federal prosecutors, as Donald Trump did before that, as Barack Obama did before that, as George W. Bush did before that. You get the picture. Biden wanted to be able to say, I am not interfering in the investigation of my son. I'm even letting a Trump appointee head it. I have nothing to do with it. Now, out of the blue comes an IRS agent saying, if Hunter Biden's last name were anything other than Biden, if it were Jones, he wouldn't be getting this baby-like treatment that he's getting. Now, we don't know what the whistleblower meant by this, but we do know that this current, not former, IRS agent who purports to know about the investigation of Hunter Biden's alleged income tax evasion has come forward under the Federal Whistleblower Act and has stated publicly, I can testify under oath that Hunter Biden is getting special treatment because his father is the president of the United States. Now, is that going to change the pace of the investigation? We don't know. Is that going to provide the investigators something that they don't already have? We don't know. Does this person have an axe to grind, or is this person giving a truthful opinion of the investigation of Hunter Biden? We don't know. But we should know more about this soon. While all this is going on, Michelle Obama, the highly respected wife of the former president, has been trying to sell a book. She doesn't have to work too hard at selling this book. It's been number 1 or 2 in the bestseller, the New York Times and the Wall Street Journal's bestseller list for the past several months. But in a television interview that she gave yesterday about the book, she was asked a lot of questions, and she expressed an opinion about the shooting of Ralph Yarl. Ralph Yarl is the 16-year-old African-American teenager who mistakenly knocked on the door of a house where he mistakenly thought his siblings were. The parents had sent him to pick up the siblings and bring them home. Instead of answering the door by saying, I'm sorry, you have the wrong house, the owner of the house opened up the door and fired a gun, which went through a glass window and hit Ralph Yarl in the head. And then while Ralph Yarl was on the ground, the homeowner fired the same gun, another round, and hit him in the arm. And then the homeowner called the police on himself. Well, that homeowner has been charged with aggravated attempted manslaughter and aggravated assault. If you put those two crimes together, this homeowner, who is 86 years old, is facing 20 years in jail if convicted of everything for which he has been charged. Mrs. Obama expressed an opinion on guns in America in response to a question about this Ralph Yarl tragedy. Listen to what she had to say.
We are the only developed country on the planet where its citizens can have unfettered access to firearms. Mm-hmm. That is not a good thing. Mm-hmm. And more of us have to feel strongly about it, and particularly our young people. This is where democracy comes in. Voting, all this stuff is decided in the ballot box.
Wow. Where in America can you have unfettered access to guns? Nowhere. Every state in the union has some mechanism for regulating guns. There may be, I'll correct myself, there may be a few states where you can buy a gun, but you have to buy it, and you don't need the state's permission, but you have to buy it from a federally licensed gun dealer, and that gun dealer records in a government registry that you own the gun. The Supreme Court has said the right to keep and bear arms is not a second-class right. It's in the same category as the rights in the First Amendment, Second Amendment, First Amendment, same category of rights. They both protect fundamental liberties. First Amendment protects, among others, your right to free speech and free press. Do you have to register your printer or your laptop or your iPhone in order for you to, or your bullhorn, in order for you to exercise the freedom of speech or the freedom of the press? No, you don't. But in every state in the union, you either have to register the gun or the feds have a record of the fact that you own the gun, and they shouldn't. Why shouldn't they? Because one of the purposes for the Second Amendment is to allow you to shoot bad guys when the police can't be there, and to shoot at agents of the government when it is taken over by tyrants. That's not me. That's Justice Scalia in the Heller opinion in 2008. Justice Thomas in the Bruin decision of last year, June of 2022, said that the right to own guns is the same as the right to carry them. Mrs. Obama, you are incorrect. We do not have that unfettered right. But even more dangerous is what she said about the ballot box. She suggested that because this could be, in her view, corrected or addressed at the ballot box, that somehow voters in a state could vote to take away your right to keep and bear arms. Mrs. Obama, that is not the United States of America. The right to keep and bear arms, according to the Supreme Court, is the present modern-day extension of the ancient right to self-defense. Where does that right come from? It comes from our humanity. It's a natural right. The First Amendment, the Second Amendment doesn't grant the right to keep and bear arms. It restrains the government from interfering with that right. If all the world but one were of the view that guns should be illegal, the world would have no more right to take away guns than would the one if he had the power to take away guns from the world. If everybody in the United States were of the view that guns should be illegal, everybody but one, everybody of that view would have no more right to take guns away than the one who's of the other view. Why? Because these are natural rights that come from our humanity. They don't come from the government. They're not subject to the ballot box. That's not me. That's the Supreme Court of the United States 3 times since 2008. You can look it up if you want. Heller versus the District of Columbia, McDonald versus Illinois, Bruin versus New York Rifle Club. And finally, Alec Baldwin lucks out again. The state of New Mexico today dropped one of the 2 charges against him. The first charge is what's called a 4th-degree offense of reckless endangerment, using a dangerous weapon in a reckless manner. This could be the same as you're teeing off on the golf course and you don't look behind you to see if someone's behind you. You go to swing the golf club, you hit them in the forehead and they're injured. That's reckless endangerment. That's a maximum of 18 months in jail. One of the 2 charges against Baldwin is this reckless endangerment with a dangerous instrument. That's 18 months in jail, maximum. And if you don't have a prior conviction, a prior felony, it's 0 time in jail. However, he was also charged with using a firearm illegally. If he were convicted of that charge, it would be a minimum mandatory 5 years in jail, plus the minimum mandatory 18 months in the other charge. It would have been 6.5 years in jail. Why did they drop the charge of using the gun recklessly? Because that charge didn't exist. It wasn't a crime in New Mexico at the time that Baldwin is alleged to have pulled the trigger that killed, unfortunately, it killed a young producer who was on the set. And because the Constitution prohibits ex post facto laws, prosecuting somebody for something that wasn't a crime at the time they did what the government says they did, but became a crime afterwards, the prosecutors in New Mexico quite properly decided to drop that allegation against him. A lot of bitterness. You'll read about it tomorrow. His defense lawyers are verbally attacking the prosecutors. The prosecutors are attacking the defense lawyers. But the defense lawyers did the right thing in pointing this out to the prosecutors. It's actually an embarrassment to the prosecutors that they would charge somebody with a crime that wasn't a crime at the time he did what the government says he did. In any case, bottom line is Baldwin is now facing only the reckless endangerment charge. It's only 18 months in jail. If he pleaded guilty to it tomorrow, he'd get 0 time in jail and he'd go on with his life. More as we get it. Judge Napolitano for Judging Freedom.